Thank you everyone for joining us this evening for the HRLA's panel discussion entitled The Right to Have Rights, Perspectives on Statelessness in the UK and Beyond. We are really grateful to Pump Court Chambers for hosting us on Zoom, in particular Daniel Gutters and Scott Haley. I'm Rebecca Hacker. I'm a member of the HRLA's Young Lawyers Committee and an immigration caseworker at Wilson Solicitors. This event is a collaborative project with my colleagues Camilla Zapata-Besso and Marianne Chunle on HRLA's Executive Committee. If you're not already an HRLA member, I would encourage you to join us. We regularly host events on topical human rights issues with speakers from across the legal profession and others working in the human rights sphere. HRLA's annual bursary for human rights internships has also just opened, so I encourage anyone interested in that to take a look at the details on our website. Turning to today's event, we have a brilliant lineup of speakers who are going to share their perspectives on the human rights implications of statelessness. There are estimated to be over 10 million people in the world today who find themselves stateless. The term stateless is defined in law in the 1954 Convention relating to the status of stateless persons as a person who is not considered as a national by any state under the operation of its law. In the UK, the issue of statelessness has received increased attention in the media and public discourse in recent years, in particular following the increased use of citizenship stripping measures as a counter-terrorism tool, notably in the case of Shamima Begum. Today, our speakers are going to shed light on what statelessness really means, how and why it arises, and the human rights implications of being stateless. They're also going to discuss what can be done to address statelessness, both in terms of tackling its root causes and increasing respect and protection for those affected. All of our speakers today are at the forefront of raising awareness of statelessness, empowering stateless people to share their stories, increasing their access to legal protection, and ending the exclusion and discrimination that can come with living without a nationality. We're incredibly lucky this evening to be joined by Christiana Bukalo, who will be talking about her work as a stateless activist and her groundbreaking State Free platform. Amal de Chickera, who will be discussing the context in which statelessness arises, its impact on access to human rights, its nexus with discrimination, and also the implications of COVID in this context. Also Judith Carter, who will be speaking about the UK's statelessness leave procedure, the Home Office's approach to this issue, and the relevance of human rights law. We'll also be joined by Khadija Badri of the European Network on Statelessness, who will be talking about childhood statelessness in Europe and ongoing work to address childhood statelessness, and Eric Fripp, who will be discussing the case of Shamima Begum and the responsibility of legislators in that context. Johanna Bezzano will also be joining us for the Q&A discussion at the end to respond to questions about the UK's statelessness leave procedure and her ongoing work on applications for stateless clients. Each speaker is going to present for about 15 minutes, and then we will have a Q&A session at the end in which audience members can submit questions. That will last for 20 to 30 minutes, depending on timing. I ask that if you have questions, you share these in the Q&A function, and we will pose those questions to the speakers at the end. If your question is directed at a particular speaker, please specify that. I'm also shortly going to share an information sheet in the chat box, which has kindly been prepared for us by Eric Fripp. This contains extracts of key legal provisions relevant to statelessness and guidance, which is a useful supplementary source for our audience while we're having this discussion. I will just pop that in the chat box now. So hopefully everyone can access that. Without further ado, I will introduce our first speaker this evening, Christiana Bukalo. Christiana is a stateless activist based in Germany and Senior Program and Business Development Manager at Global Digital Women. She is currently building a groundbreaking online platform called State Free World, aiming to bridge the communication gap between those working on statelessness and those experiencing it. Christiana has worked closely with the Institute on Statelessness and Inclusion and is a trustee of the European Network on Statelessness. Christiana, thank you for joining us this evening.
Thank you. Hello, everyone, and thank you also for inviting me. I'm very happy to be part of today's panel. Also very much looking forward.
I think you may be on mute.
Am I? Because, am I unmuted now?
I can hear Christiana very well.
Okay.
Okay, can everybody hear?
Yeah.
So, yeah, there's some messages in the chat about.
Okay, that was my technical problem, not yours.
Okay, well, it would be important. You can hear me now. Okay.
Apologies.
No
Great
worries.
start to the conversation.
I was
Thank you
just
very
going to
much for joining us.
Thank you for inviting me to this panel. That was what you missed. I'm very much looking forward to today's discussion. And I was just going to say it would be very important that both of us can hear each other as we will have a conversation.
That's the key, yes.
Yeah. Okay.
Well, that was a great icebreaker. Thank you for joining us, Christiana. So just to start off our conversation, I'm sure you have a lot to share with us. I was just going to comment that particularly for lawyers, but I think for a lot of people, statelessness often comes across as a very abstract technical concept. And for lawyers working on this issue, you can often find you're trying to prove a negative, a lack of a nationality, and that becomes quite abstract. Can you tell us from your experience what statelessness really means and what tangible effects it can have on a person's life?
So I guess what it means actually changed in my course of development. So I was born in Munich, in Germany, and as my parents, when they came over to Germany, didn't have sufficient documents and information to prove their identity, we were affected by the topic of statelessness since then. And I also have two younger sisters who have been through the same and are going through the same in the moment. And we were younger, the topic of statelessness itself was not too much of a focus for us. By that, I mean, of course, it was very important, especially for my parents, right? But me as a child, I didn't really understand what was happening. I knew that we were seeking for asylum. I knew that we had issues with the topic. I grew up, at least until I turned 5 or 6 years, we were in an asylum home. And at some point we were able to move into a place for ourselves. And I knew that my parents had struggles, especially with the asylum officers, but I didn't really understand what it means. And then at some point I noticed, especially in comparison to friends, which you then get to know in school, I noticed that we had a different situation and just different circumstances, which meant that, for example, when others traveled with their families, we weren't able to do that because we didn't have documents to go somewhere else, or we didn't have travel documents or a passport. Then there were other things, like whenever I had to or wanted to register to different things, and whenever that service, for example, was tied to my identity, and this identity was kind of defined in terms of my nationality, I had issues registering for this. So as I grew older and as I had to administer my own life, those issues became more obvious to me. Because then I was taking care of my own life, and that meant that I had complications whenever starting a job, because the person in the HR department was confused about what exactly is meant by statelessness. Then there are like very basic things like verifying my identity on Airbnb. So when I wanted to, at some point they had a reset of their privacy policies and people were asked to upload their ID cards. So my ID card looks different, obviously, and the system didn't know what a stateless stateless or a ID card of a stateless person looks like. So I had to do that, I think like 5 or 6 times. And so those are the small things that you don't really think of in the beginning, or it's hard to think of those things if you're not really affected by it. But also, I think one thing that's very important to say and mention is that this is a case, in my case, I'm actually comparably very privileged because I live in Germany. So in other countries, there are other issues. And I had the opportunity to go to school. I have the opportunity right now to open a bank account because I have documents. I have access to public health services. And that is because in Germany, that is tied to my work allowance and to my residence permit. So what I'm noticing right now is the issues I have when I want to travel, and the fact that I'm not able to vote, which means that I'm not able to participate in politics in the country I've been living in ever since.
Thank you. That's really enlightening to kind of hear those different effects that it's had on your life. You mentioned, the situation being different for stateless people in other parts of the world, with examples like access to education. Have you found in connecting with stateless activists from other parts of the world that you've found things in common in your experiences, or things that you noticed that were striking, that were different?
Yeah, so different things. I think in general, stateless people oftentimes feel like what they're experiencing are very individual situations. But in the moment in which you actually talk to other people, you notice that although our situations might be, it's individually experienced as such as individual, but then again, the impact is rather a collective impact every one of us experiences. And something that is very obvious to me, at least, is definitely the impact it has on a person mentally and psychologically. Also the impact it has on how a person defines its self-worth, actually. And one thing that I've been thinking a lot about in the last couple of weeks is actually, I feel like I often hear this, I don't want to say statement because it's phrased differently, but I feel like stateless people often feel like they need to prove that they are worthy of being wherever they are, and that they are worthy of getting access to different things and services in the country they live in. And that this proof is often given with like education or participating in the environment you're living in the society you're living in. And actually right now I am at the point in which I am super upset about this, because I feel like education has nothing to do with your worth as a human being. And being more or less educated shouldn't have anything to do with whether or not a country accepts you and is willing to verify you as a person.
Thank you for sharing that. And can you tell us a bit about how these thoughts and reflections that you've had on these experiences have led you to your activism?
I have to say that so these thoughts are something that arise actually in the process of becoming an activist. And I also have to admit that I'm still confused about whether or not I identify myself as an activist. I know that other people do describe me as an activist, but that was not necessarily the plan actually in the beginning. So what happened is that I experienced a personal incident that was very traumatizing, which was that I wanted to travel to Morocco. So in my case, I obtained a travel document at the age of 18. It was called Travel Document for Stateless Person. And right now, I have another document which says Travel Document for Foreigners. But regardless of what it's called, it allows me to travel. And I traveled to Morocco, and I traveled on my own. And I was very much looking forward to it because as I wasn't able to travel before that, I don't really have too much lived experience with going to other countries. And I flew there, and before I flew there, I did research, obviously, because traveling is tied to a lot of anxiety for me and uncertainty because I don't really know what to expect. And I also know that people maybe don't really know what to expect from me as a stateless person. So I wasn't sure whether or not I'm even allowed to travel there. And I tried to find information in the internet and tried to reach out to different institutions, to the asylum office in Germany, in Munich, and also to the embassy, which didn't really help because they didn't really understand. Some of them never even replied. And so what I did is I looked at the tourist website of Marrakesh, because I had already booked the flight, and just tried to compare which people are allowed to travel to Morocco. And what I saw is that German people were allowed to travel to the country without a visa. So as my document is issued in Germany, and I've lived here ever since, and I don't have any other thing to compare myself to, I thought that I would be able to travel there as well. So what happened was that I flew there, and so the security staff in Munich actually also checked my documents and didn't say anything. I remember them even that one man even mentioning that he hasn't ever seen this document before. And we had a conversation about statelessness, which often happens when when my document is being checked. So, well, I landed in Marrakesh, and at the airport, I was confronted with the fact that I'm not allowed to enter the country without a visa. So they wouldn't let me in, and I was forced to remain at the airport and wait at the airport until the next flight back to Germany was scheduled. And that was about 20 hours after I landed. So that was very, shocking, the moment, actually, as such. And what happened internally in my mind was that I actually didn't really understand how this could have happened. I was super confused about the fact that I wasn't able to protect myself from this situation. And I was also very embarrassed by it because I felt stupid, because I obviously didn't know how to find the right information for myself. And at some point when traveling back home, I at some point realized that this was actually not my fault, and that the issue is that although somebody came up with statelessness, right? But the problem is nobody came up with a solution for as to how stateless people are supposed to live with this. And so what I noticed is that there's a lack of information, and I restarted a research journey, I would call it, to find a single source of truth. That was my first goal. I couldn't find that, but I did find other institutions, which were the ENS and the ISI, luckily. And actually, this whole process led me to decide, through this process, I decided to do something, although I really have to say that in the beginning, I was super skeptical, and I never really wanted to focus my life on the topic of statelessness, because I was a person, my professional background is in media and communication, and I have no background in law and politics. And I chose to focus on the positive things of my life. Well, now I'm deep in the topic of statelessness and think about it a lot. But before that, I actually never thought about it, and I tried to ignore it. So things have turned around a bit, but I can't really. So this was one incident that led me to what I'm doing right now. But everything else just happened in the process after that decision was made.
Thank you for sharing that with us. And I'm sorry that you had to go through that experience. Can you tell us how? So I've read about your state-free platform that you're setting up online, and it sounds like that's an attempt to address this lack of information out there. So I'd be interested to hear more about your aims in setting up that platform, what the change you're hoping to achieve through it.
Mm-hmm. So the aim has changed a bit in comparison to how I started. So in the beginning, the aim was actually The aim was not to create a platform. The aim was to find an institution that knows all there is to know about statelessness so that I could support that institution in communicating the information. So I really never wanted to start something on my own. At some point, I noticed that there are different organizations who have knowledge, and I felt like the information is very fragmented, and that there might be something needed that just simply summarizes all of this and is maybe easier to find also. And that was stage number 2. And the third stage was that at some point I noticed that just recreating content didn't make sense to me, because there are these great organizations and they're experts in what they're doing. So maybe something else is missing, at least in my perspective, and that was a place to communicate to each other. Because what I was noticing is that there were stateless people and then there were different organizations. And I felt like what was missing is this one place and this one environment in which everyone that has something to do with the topic can actually talk to each other. And in my vision, this would mean that all of those people can actually co-create the single source of truth, because by collecting all of these experiences, all of this knowledge, and sharing thoughts, comments, and feedback on it, I feel like in the long run and long term, this has potential to become a single source of truth for people who are affected by the topic.
That's really a powerful message, actually, sort of finding a source of truth, and also that being a joint project of sharing people's stories, not just coming from one place. I might just share in the chat the link to your online platform if you're happy with that.
Yeah, I'm happy.
Yeah, I'd really encourage the audience or attendees to have a look. It's a platform for connecting stateless activists and those working in the field, and also allies of stateless activists, as you've described it. Is that right?
Yeah, that's right. And maybe not so much stateless activists, but mainly just people who are stateless. And the thing is, right now, the platform is still in the development phase. So we have the landing page online and people can already sign up. We have about 120 registrations right now, which is great, and it grew organically. And we are currently developing the platform. It will be a combination of social media and forums. So we actually have like 2 tabs. I can see it in front of my eyes, but I can't show it yet, unfortunately, because it's still very rough. But yeah, we're planning to launch the platform as such, on which you can actually register pretty soon.
Brilliant. Thank you, Christiana.
Thank you.
Thank you so much for chatting with me. I'm going to move on now to our second speaker, and look forward to kind of speaking to you more during the Q&A session.
Thank you.
So our second speaker is Amal de Chickera. I'm just going to, there we go. So Amal, thank you so much for joining us this evening. I'll just give a quick introduction. Amal is a co-director and co-founder of the Institute on Statelessness and Inclusion, the sole human rights organization dedicated to working on statelessness and the right to a nationality globally. Amal has been researching, writing, speaking, and serving as an expert on statelessness and related issues for the UN, NGOs, and academia since 2008. He's a human rights lawyer and member of the Sri Lankan Bar, and he currently teaches a postgraduate course on statelessness and the right to nationality at Middlesex University in London. So Amal, I will hand over to you and look forward to hearing what you have to share with us.
Thank you very much, Rebecca, and thank you to the HRLA for inviting me to speak at this event, and for the wonderful panel that you've pulled together. I feel particularly privileged to be following on Christiana, who I have a deep admiration for, and you can tell why based on that interview. So yes, my task is to zoom out a little bit and speak to you about statelessness as an issue which is of global proportions and look at the way statelessness is experienced around the world. And the panelists after me would then zoom in and focus more on the UK context. And in thinking about how to approach this, given that obviously I'm speaking at a Human Rights Law Association event, I thought I would really focus on statelessness as a human rights issue. And that's something that is very easy for me to do because the way ISI approaches statelessness is very much from a human rights perspective. So first, let me give you a sense of the scale of the issue, and then we can go through some of its impacts and some of the challenges and kind of strategies around advocacy to address statelessness. I will also touch briefly upon the COVID-19 impact and on citizenship stripping towards the end of my little presentation. So globally, we estimate that there are at least 50 million stateless people around the world. The numbers are very difficult to come by. So this is a guesstimate more than an estimate. And it basically has been arrived at by piecing together information that UNHCR publishes on statelessness, as well as looking at the global stateless refugee population, who aren't all included in UNHCR's statelessness figures, as well as the stateless Palestinian population, who again are not included in UNHCR's figures. But in addition to this, there are potentially tens of millions of people around the world whose nationality is under risk, who are facing an imminent risk of statelessness because of the particular situation that they face. For example, in Assam, in India, currently there are close to 2 million people who've been excluded from a national registry of citizens. And this basically means that the Assamese government treats these 2 million people as foreigners. And there's now an appeal process going on where each of these people can appeal to a foreigners tribunal in order to reverse this decision. But the likelihood is that the vast majority of them would end up being stateless. So it's very much a live issue. It's an issue which continues to impact people around the world today. It's an issue which people are born into because they cannot access the nationality of their parents, or because their parents do not have a nationality which they can pass on to their children. And it's also an issue which is created through governments taking active measures to strip individuals of their citizenship or to exclude entire communities of their nationality. So it's very much a human rights issue, and I think it's important to emphasize this because traditionally statelessness has been approached primarily as a protection issue. The two main UN treaties which relate to statelessness are the 1954 Convention, which relates to the status of stateless people and is a sister convention to the Refugee Convention. So it's drafted along similar lines, and it really focuses on protecting stateless people in a third country context. And then you have the 1961 Convention on the Reduction of Statelessness. And whilst statelessness is a protection issue, it is also a human rights issue, and I would argue that it is primarily a human rights issue. And it's a human rights issue in two ways. Firstly, a person is stateless because their right to nationality has been denied. So these are people who should have a right to nationality, who do have a right to nationality, who've been deprived of the enjoyment of that right by the country in which they live, by the country to which they have ties, by the country which should have an obligation under international law to grant them nationality. And secondly, as a result of nationality deprivation or the denial of the right to nationality to begin with, stateless people find themselves unable to access other human rights, or with significant barriers placed before them in order for them to access those rights. And these range from democratic rights. Christiana spoke about her right to vote, so the right to political participation. They relate very much to movement and liberty and security of the person. Stateless people are disproportionately likely to be impacted by immigration detention, for example. And it also relates to socioeconomic rights, access to education and healthcare, a livelihood, and issues which are very much also coming to light in the COVID-19 context. And so this is why at the Institute on Statelessness and Inclusion, we very much focus on statelessness as a human rights issue. We engage in advocacy before UN treaty bodies and other human rights mechanisms. And we work on issues such as the child's right to nationality, the discrimination as a cause and consequence of statelessness, and indeed citizenship stripping. Now, in this context, two questions that I often come back to, which I think are quite fundamental questions if we are to move forward from this situation that we find ourselves in, where there are millions of people who are stateless or at risk of statelessness, and who, on the basis of their statelessness, they are denied access to certain rights. Why are people still made stateless today? And why is statelessness perpetuated today? In other words, why are people who have a nationality having that nationality deprived? And why are people born into situations where they cannot access the nationality of the country which they should be entitled to? And when trying to answer these questions, you realize that statelessness is most often a deeply political issue. It's a construct which is imposed on communities. Minority communities make up more than 75% of the stateless population in the world. It's a system that's imposed on women. In 25 countries, women don't have equal nationality rights to pass citizenship onto their children. Just think about that. Women who cannot pass their citizenship onto their children on the same basis that men can. 25 countries, that's 1/8 of the countries in the world, still have such a system in place. And it is a system which is perpetuated by politics of populism, politics of xenophobia, and politics of majoritarianism. And so we find that it is often politically expedient to disenfranchise communities, to make people stateless, and to use this disenfranchisement as a way of excluding communities, as a way of excluding individuals, and as a way of justifying the denial of their rights. And what we're seeing here is, to put it very bluntly, a weaponization of nationality by states and by people in power in order to control, in order to exclude, and in order to justify human rights deprivations. And the moment you start understanding statelessness in this light, a lot of the mass deprivations of nationality that we've seen in the world, and a lot of the ways in which individuals are targeted for their political dissent, for their use of their freedom of expression, etc., it starts to make sense. So why were the Rohingya mass denationalized in 1982? What is happening in Assam right now, and why? Why is it that over 100,000 Dominicans of Haitian origin were stripped of their citizenship? Why is it that ethnic Russians in Latvia were denied their citizenship? It starts to make sense that this is a targeting, particularly of minority communities, in order to exclude and to control them. And this then leads to two other questions, which I think are necessary for us, particularly those of us in the human rights sector, to confront ourselves with and to grapple with in order to try and progress further. And these two questions are as follows. Firstly, why is it strategic for states to weaponize nationality and to use it as a tool of deprivation? And secondly, how come it's so easy for states to do so and get away with it? And let me just briefly talk about both of these questions, or share with you my reflections in terms of both of these questions. So in terms of the first question, why is it so strategic and so expedient and convenient for states to go down the route of weaponizing nationality and using this as both a carrot and a stick in terms of its how it deals with minorities, how it deals with human rights defenders, etc. And this raises questions about how we understand human rights. Because if you look at the core human rights treaties, the two covenants on human rights, as well as the treaties on the rights of the child, or on racial discrimination, etc., you will find that most human rights are to be enjoyed by all without discrimination, regardless of nationality. It's just a handful of rights. So the right to political participation, uh, the right to freedom of movement, but with significant limitations, and in very specific contexts, developing countries by declaration with regard to economic rights under the ICESCR. These are the only rights in which citizens are allowed to be given preferential treatment under international human rights law. But in practice, what we find is that citizenship, and indeed documentation, is often an essential prerequisite to enjoying basic human rights, whether it's access to healthcare or access to education, or whether it's the freedom of movement or the right to work, uh, any number of human rights. Without a citizenship, it's much more difficult for you to enjoy those rights. And without a citizenship, it's much more difficult for you to access justice and to challenge deprivations of rights when you experience them. And this then raises the question, how have we allowed things to get to this stage? Why is it that these artificial barriers and differences in treatment between citizens and non-citizens have been allowed to take root and determine how we conduct ourselves as societies, and actually made it into a strategically beneficial system for states which are pursuing populist agendas to deprive communities of their citizenship in order to control them. And then the second question is, why is it so easy to get away with this? And here we see often politics around security, politics around immigration control, and this is very relevant to the discourse in the UK as well, trumping human rights considerations. And the moment that becomes the framing of a conversation, it becomes very difficult to then hold on to the fundamentals of human rights. And it is in this context that it's particularly important to be promoting the right to nationality for all, and to be promoting access to rights for all, regardless of whether their nationality, their right to nationality has been protected or not. Now, let me conclude very briefly by touching on the COVID-19 situation and what we see happening, which Eric will speak to in further detail in terms of citizenship deprivation. So with the COVID-19 pandemic, what we have seen at ISI is that this has brought to light, in ways that haven't been obvious before, the underlying structural discrimination that stateless people face. And it has suddenly confronted people who previously were less interested in statelessness or less aware of statelessness, of the way in which the world, the injustices of the world are stacked up against stateless people, to the extent that they are unable to live dignified lives and unable to contribute to society in a way in which everyone should be entitled to. And with COVID-19, with conversations around the vaccine, with conversations around state relief for people who have lost their livelihoods, we found stateless people being excluded from these processes. We also found in some countries stateless people being scapegoated as minorities who were vectors for the vaccine, for example. Again, in line with this populism around which kind of stateless people tend to be targeted. And so, and this is something which Khadija may also be able to speak to when she, and I know she's focusing on childhood statelessness, but ENS just earlier this week published a fantastic report on the access to healthcare of stateless people in the context of COVID-19. And that also raises some concerns about the situation in the UK as well. So we see that globally, stateless people are disproportionately disadvantaged in terms of COVID-19. And it is something which is of deep concern. And finally, I'm aware that I'm running short of time. Finally, let me just touch on citizenship stripping. And again, just flag the issue of, as states give themselves more powers to address terrorism and to protect national security, this has also led to states taking on more powers which allow them to strip individuals of their citizenship as a counterterrorism measure. And this is a practice which to us at the Institute is deeply concerning because it has led to significant overreach in a number of countries. Countries like Bahrain and Turkey, for example, where human rights defenders, political dissidents, journalists have all been targeted through these measures. But also in countries like the UK, where these measures have been abused and used in a way which leads to people being made stateless or people being denied their citizenship with no real due process of the law in which to challenge such decisions. We worked with a number of experts to develop a set of principles on the deprivation of nationality as a national security measure. And what these principles do is they articulate existing international law standards related to citizenship deprivation. And they bring together standards found in different places. And they, when you look at all of these standards collectively, you see that actually the problem isn't a lack of a coherent international law standard on these issues. There's very clear standard in terms of the protection of the right to nationality and the very few exceptional situations in which states may be able to deprive citizenship, but the various safeguards that have to be ensured in order for states to remain in compliance with the international obligations when they do so. And what we found when looking at these principles is that most states, certainly not the UK, do not comply with the standards in how they go about depriving individuals of their citizenship. And this is another matter of great concern. So let me pause there. I apologize, I was rambling a bit towards the end, but I just wanted to give you a very brief kind of snapshot and overview of how statelessness plays out globally. And I wanted to push you and push us collectively to think about this, not as the black letter law technical issue that it is sometimes considered as, but rather as very much a political issue and a strategy and tool used by repressive states and by populist states to target minorities, to target dissidents, and to punish them by using nationality as a weapon. So let me pause there. Thank you.
Thank you so much, Amal. I'm now going to introduce our next speaker, Judith Carter. Let me just find you, Judith. Judith is a lecturer at the University of Liverpool and a solicitor at the Liverpool Law Clinic, where she works on applications by individual clients for a statelessness residence permit through the UK's statelessness determination procedure. Judith has extensive experience of advocacy in this field and co-authored the Immigration Law Practitioners Association's guide, Statelessness Applications for Leave to Remain, a Best Practice Guide, 2016. She also engages in training students and legal practitioners in this area. So Judith, I will hand over to you to discuss your experience in this area. Thank you.
Okay, thank you very much for inviting me to speak about our work on this panel. And thank you to the previous speakers who have really highlighted what this issue means to our clients. So this talk addresses really how domestic human rights law is in fact of limited effect in this procedure, which is to request leave to remain on the grounds of statelessness, and also in deportation proceedings. So first of all, I explain how the procedure works and what its policy objectives have been. And then briefly, I look at relevant ECHR jurisprudence. And then I examine the problems we have even arguing human rights law on behalf of our clients in the UK's legislative framework. And lastly, I look at some hope with how a stateless person who is a client of ours has had their deportation action against them suspended on the grounds of their statelessness. So in the handout that you've got in the link that was provided at the end, there's the immigration rules for the application procedure. There's a link to the guidance to caseworkers on how the procedure should be operated. And there's also set out the rules on the criteria for revocation of deportation orders on human rights grounds. So I'll be referring to those, but not in detail. So in 2013, the Home Office introduced a procedure to allow a grant of leave to remain to people who are stateless and not admissible to any other country. The rules say the person must come under the definition in the 1954 Convention, so they must not be considered as a national by any state under the operation of its law. They mustn't be excluded from the definition of a stateless person under the clauses which are broadly similar to those in the 1951 Convention. So there are fault-based and alternative protection exclusion clauses. The general grounds of refusal apply to these applications. So they apply to all migrant applications except refugees and those requesting humanitarian leave. There is provision for family reunion, and the person will usually get a 5-year residence permit, and then they can request settlement or indefinite leave to remain if they still fulfill the same requirements at the end of that period. So in 2013, the stated policy objective was to address a potential gap in the UK's protection response. And that word protection is important. And it was also to ensure compliance with international treaties and help deal positively with cases which might otherwise be incapable of satisfactory resolution. So it was looked at as an application of last resort to be made after a human rights application or asylum application has failed. However, from then on, the Home Office has flatly refused to treat statelessness leave applications as protection claims, so the procedure is without some guarantees which are available to asylum seekers and those seeking humanitarian protection under Article 3 of the ECHR or Article 8 of the ECHR. The third version of the guidance simply says, we'll ensure we comply with our obligations under the UN Statelessness Conventions, and the word protection has been lost. They also want to tackle abuse from those who abuse the procedure, of course. So the procedural protections which are lacking is there's no right of appeal to an immigration tribunal, and work seeking leave under this procedure isn't in scope of legal aid in England and Wales, and somebody needs to apply for an exceptional case funding legal aid certificate. And that has bureaucratic obstacles. There are lower fees to lawyers. It's more bureaucratic to obtain payment for that work. It's not an appealing source of income for a lawyer. And the application isn't suspensive. Also, emergency support for failed asylum seekers or others who otherwise are unable to leave the UK isn't automatically available to people who submit an application in this procedure. So there has been litigation on the meaning of the definition of statelessness, the meaning of admissibility, and on the standard and burden of proof. And the Court of Appeal has preferred the Secretary of State's view to the UNHCR's. And the evidential standard, therefore, is the balance of probabilities. The burden of proving the negative is on the applicant. So now, very briefly, to consider the European Convention jurisprudence in the European Court of Human Rights. So there have been some Article 5 cases. There have been some deprivation and loss of nationality cases. Loss of nationality is in fact less important to our clients because we're not usually seeking to litigate to reacquire a nationality, because if the person is stateless, they get a relatively generous form of leave. So we're showing that they are trying to establish or acquire a nationality, but usually we're not entering into any kind of litigation with the foreign state. And that's in accordance with the UNHCR position that the most somebody should have to do is, for example, make a declaration at an embassy that they want to reacquire their nationality. So the relevant jurisprudence would be Hoti versus Croatia, which was 2018, and Judith Carter versus Hungary, which I think is 2019. And there the European Court considered that a host state has positive obligations under Article 8 towards a long-term resident migrant who is stateless. So the minimum is there must be acceptable and effective procedures to allow regularization of their resident status, and there should be access to documents to enable a normal life, but there's no right to nationality of the host state. So what we're looking at in our practice is evidencing that a failure to take a correct decision is likely to lead to an interference in Article 8 rights if the consequences are serious enough, amounting to an interference. And Christiana has outlined very well the kind of issues that stateless people face, and they also face in the UK the hostile environment, where effectively immigration status is required at many intersections with the state, including healthcare, higher education, driving, getting married, renting a house, and getting a job. So it's very easy for us to show that our clients would otherwise suffer some human rights breach if they don't get leave to remain and they're stateless. So what we did, noticing that our clients were often street homeless, they've been in unlawful detention, they may have fallen into criminality due to poverty, and they've been unable to develop their private or family life, is we made representations in support of a case that a refusal to grant them leave to remain would be a breach of Article 8. So some of our clients were granted leave under the statelessness procedure, and we used individual case contracts to get legal aid funding initially to judicially review the first refusals in the absence of any appeal rights. But in 2014, the Immigration Act removed most appeal rights, so only those who had protection claims or human rights claims still had a full right of appeal. So then in order to get a right of appeal, we want to frame our clients' applications as human rights applications, but the Home Office procedure doesn't encourage that, to say the least. So the Home Office routinely stated that they would not consider any human rights arguments unless the applicant chose to make a fee-paid human rights application on a different application form, possibly subsequent to their statelessness application if it was refused. So on receiving these refusals, we lodged appeals in the Immigration Tribunal, and we also requested an administrative review of the decision. So the administrative review is kind of a SOP for those who don't have an appeal right, and it's an internal administrative review, and it can look at casework errors, including whether the law and policy have been applied correctly. What happened was that our appeals got listed by the tribunal, but also we were successful in our administrative reviews. And we have never managed to get to the point where we've argued in the tribunal about their jurisdiction and whether we could actually have a human rights appeal. But this has happened. So it's happened with practitioners who work on applications for leave to remain because of domestic violence. They were doing exactly the same thing. They were tacking on a human rights based claim to a domestic violence application. And the case of MY Pakistan versus the Secretary of State has been granted permission to appeal to the Court of Appeal, having lost at the first tier and upper tribunal. And it's making exactly this point, that a process where you have to make a separate human rights application, which is fee paid, in order to get a right of appeal on a human rights matter, where the substance of your application would naturally raise human rights issues, is unlawful. And that's what the Court of Appeal is going to consider. And apologies to non-immigration lawyers, because this system is a nightmare, and the latest court decisions end up trying to distinguish human rights claims from human rights applications in order to work their way through the legislation. So another area where we've had some success in establishing that statelessness is a human rights issue in the UK framework is in requests for revocation of deportation orders on the grounds of statelessness. So in two cases, we argued that statelessness is a very compelling circumstance. And you'll see in the handout that paras 398 to 399 of the immigration rules set out the criteria by which the Home Office can decide to revoke a deportation order. And once you've worked through any lack of family life or otherwise considered private life, you get to something called very compelling circumstances. And the Court of Appeal decided in 2018 that they would not decide that statelessness was a very compelling circumstance, because on the facts of the case in AS Guinea, the applicant hadn't done enough to establish their statelessness. However, in a case that was settled in January of this year, it appears the Home Office has accepted that position. So we asked for determination of statelessness as a prior fact in a revocation request in 2016. We got a decision in summer 2018. The criminal cases team refused, but gave a right of appeal, and that appeal was repeatedly adjourned for 2.5 years until the status review team admitted the appellant was stateless. Then the criminal team appears to have revoked the deportation order. It has granted 30 months discretionary leave, and it formally refused statelessness leave, which cannot be granted when there's a deportation order in force. So it's a rather tortuous route, but because the deportation provisions are deemed to be a complete human rights code for analysing whether a deportation order should be revoked, it seems that by accepting our client's statelessness as a reason to revoke a deportation order and grant discretionary leave, we have finally made some small step to the Home Office recognising that statelessness is a very compelling circumstance and likely to engage Article 8. Thank you.
Thank you, Judith, for giving us some insight into your work in the statelessness leave procedure and the issues arising. I'm going to now introduce our next speaker, Khadija Badri from the European Network on Statelessness. There we go. So welcome, Khadija. Thank you for joining us. Khadija is the Advocacy and Communications Officer at ENS, the European Network on Statelessness, which is a civil society alliance of over 160 organisations and experts in 41 countries dedicated to ending statelessness. Khadija works on advocacy and ENS direct engagement with stateless people. She's been at the forefront of ENS work on childhood statelessness and previously worked for Save the Children. She holds a master's degree in migration and development from SOAS and has volunteered with various organisations assisting refugees and asylum seekers. So Khadija is going to give us a presentation on childhood statelessness and ENS work in this area. I'll hand over to you.
Thank you, and hopefully you can see my slides.
Yes.
Brilliant. And yeah, thank you to the HRLA for inviting me to speak today. It's great to be among such an esteemed panel and among some friends. So for those of you who don't know the European Network on Statelessness, we are a civil society alliance of over 170 members now, based across 41 countries in Europe, all committed to addressing statelessness, and we believe that everyone has the right to a nationality, and that those who lack a nationality are entitled to full protection of their human rights. And we focus around 3 areas of work, so law and policy development, capacity building, and awareness raising. And child rights has been, and the child's right to a nationality has been a priority area of work for us since we were founded. So I'm going to spend my time sharing a bit of information about childhood statelessness in Europe and why it's still an issue in Europe. I first of all just wanted to touch on kind of some of the obligations that states across Europe have to ensuring every child has the right to nationality upheld. So it's enshrined in a number of international and regional instruments, but there are a few that I just wanted to mention here. So the Convention on the Rights of the Child, in particular, because all states in Europe are a party to this convention, and under Article 7 on the Convention of the Rights of the Child, states are obliged to ensure every child has the right to acquire a nationality. So all states in Europe are obliged to make sure the children have that right upheld. But also important are the two of the key principles in the convention. So the principle that the best interest of the child shall be a primary consideration in all actions concerning children. And, you know, Amal was talking about statelessness as a human rights issue. And we say it's never in the best interest of a child to be stateless because of the impacts it has on their access to basic rights and the rights enshrined in the Convention on the Rights of the Child. But also important in the Convention is the principle of non-discrimination in accessing the rights under the Convention, including the right to a nationality. But also important to mention, in particular in relation to child statelessness, is the 1961 Convention on Statelessness, on the Reduction of Statelessness, which outlines concrete safeguards that states must integrate within their nationality laws to ensure that children can acquire a nationality in situations where they would otherwise be stateless. And this is something that's also an obligation for states under the European Convention on Nationality. So yeah, and as I said, there are a number of other international and regional instruments where states are obliged to prevent statelessness among children. But despite this, and despite the fact that all states in Europe have this obligation under the CRC, we're seeing that children continue to be born stateless in Europe and continue to grow up without a nationality. And we see that impacting on their access to other rights as well. And so I wanted to take a little bit of time to talk about why this is still happening in Europe and why children are still being born stateless. So first of all, I mentioned that under the 1961 Convention and the European Convention on Nationality, that states are obliged to have these legal safeguards in their nationality laws that enable children who would otherwise be stateless to acquire a nationality. But what we see is that only half of states in Europe actually have safeguards in place that mean that children in any situation where they would otherwise be stateless can acquire a nationality. So we see some countries where they have safeguards in place, but they're what we would call partial because they don't apply to all children who might be born and otherwise be stateless. So for example, they might not account for children whose parents have a nationality, but can't pass them on to the child. So there might be a condition that it only applies to children born to stateless parents. But that doesn't take into account children, for example, who are born to parents from one of the 25 countries that doesn't allow women to pass on their nationality in an equal way with men. And if the child, for example, is born to a Syrian mother and the child can't acquire the nationality of the father for whatever reason, then that child's going to be at risk of statelessness if the safeguard doesn't apply to them. We also see safeguards in some countries being made dependent on the resident status either of the child or of the parents, and that comes back to that principle of non-discrimination under the CRC. But we also see situations where the safeguards are in a way that they're not automatic, so it requires an application process from the parents. And that can create potential barriers to the child acquiring the nationality if, for example, the parents aren't aware of the procedure or if there are requirements in the procedure. And all of this, even where there are full safeguards in law, all of this depends on the safeguards actually being implemented in practice. And because of the lack of awareness of the issue of statelessness, you know, children might not necessarily be identified as stateless or at risk, and so might not be referred to these safeguards in the first place. So that's kind of another consideration here that leads to statelessness for children in Europe. And we also see barriers to birth registration in Europe. So generally the birth registration rates are quite high according to the data in Europe, but we still see some barriers that affect some children and prevent them from registering their birth. And why this is important is because birth registration involves the official recording of the fact of the child's birth, and that recording often includes important information about the parents and the place of the child's birth, and the child will usually acquire a nationality either through the place of birth or the parents. So that official record is a really important kind of evidence of the child's link to nationality. And that's why birth registration and a birth certificate as kind of documentary proof of that is really important. So where there are barriers, it can create a risk of statelessness. And again, one of the barriers is that it can be made conditional on the parent's residence status or them having certain documents, which not all parents are able to provide. And this can particularly impact on Roma communities who have faced intergenerational barriers to documentation, as well as refugees and migrants who might not have the documents required. Something that we're also seeing as an increasing barrier and a bit of a concerning trend in some countries in Europe is the non-recognition of same-sex parents. So because LGBTI rights and the recognition of those rights is so varied across countries in Europe, and the recognition of kind of legal ties between a child and their non-biological parents, we're seeing in some cases that's creating a barrier to birth certificates being issued to children in those situations. For example, where a state might refuse to issue a birth certificate with two same-sex parents on it, or they might refuse to recognize a birth certificate issued by another state that has two same-sex parents on it. And there was recently a case heard before the Court of Justice of the European Union where this was the situation for a child born in Spain to a Bulgarian national and a UK national, and Bulgaria refused to issue a birth certificate to the parents, and therefore the child's access to Bulgarian nationality was impeded. And I can share the link to that case with more details. And also something we're seeing in a few countries is mandatory reporting requirements for civil registry officials, which can obviously prevent migrants with irregular status from registering the births of their children if there's the fear that they're going to be reported to the immigration authorities. So in Belgium and Germany, for example, there are requirements in law for civil registry officials. And in the UK, it's not civil registry officials, but there are some instances for health officials to report in certain cases, which might prevent people with irregular status from being in contact with the healthcare authorities and kind of as a result registering the birth of their child if, for example, they don't give birth in a hospital. And there are some countries where there aren't these requirements in law, but it's still happening in practice anyway. And finally, where parents haven't registered the birth of their child within the deadline that's written in the domestic law, according to international norms and good practice, then states should enable free and immediate birth registration, regardless of the fact that the deadline's passed. But in reality, what we see is that there are maybe additional requirements to register a birth late after the deadline. So there might be documentation requirements, there might be a fee or a penalty, or there might also be things like a court procedure or administrative procedure that people have to go through, which can create these additional barriers and potentially prevent birth registration from happening after the deadline. So to address these kind of two key areas where we see gaps in law and practice, what we call for is for immediate free access to birth registration to be enshrined and upheld for all children, regardless of their status or the status of their parents, so regardless of the documentation, the residence status, the sexual orientation of the parents. All children should have free and immediate access to birth registration and be issued with a birth certificate so that they have proof of that record. And we also call for full legal safeguards, preventing children from growing up stateless in all cases, so making sure that those safeguards can apply to all children who would otherwise be stateless, and to also make sure that those safeguards are actually implemented in practice, so making sure that the competent authorities are aware of statelessness and are able to identify children who are stateless or at risk so that they can be referred to those safeguards is really important. Having them in law is great, but if they're not implemented, then they're not helping the children that need them. And I also just wanted to mention our project briefly on understanding and addressing childhood statelessness in the UK. So it's, childhood statelessness in the UK, there has been some work on it, including by colleagues on the panel at a national level, but it has had relatively little focus and attention in kind of policy and research. So we are kind of in the middle of an 18-month project to try and better understand the situation in the UK and to try and evidence that, as well as to promote the reduction of statelessness in the UK. And so we've been conducting some research to try and evidence and understand which children are at risk of statelessness, and as well as to try and see if there's a potential explanation for the rise in stateless children registering as British citizens in recent years. So we've been doing interviews with stakeholders, literature reviews, mapping children and young people affected, as well as working with expert legal advice organisations, including Liverpool Law Clinic and Just Right Scotland, to carry out case reviews. And so we're in the stages currently of developing that research into a research report with some recommendations, and then we'll be using that to do advocacy and capacity building activities to kind of promote the reduction and prevention of statelessness in the UK. And yeah, given it's a UK focused event, I wanted to mention it as something that we're doing, and I'll share the link to our mailing list in the chat if you'd be interested, where we'll be sharing the report once it's out and published, and you can keep up to date on the project. So I just thought I'd mention that, and then I'll wrap up and quickly share information on where you can find out more on the issue of childhood statelessness in Europe. So we have a section of our website dedicated to childhood statelessness, where you can find all our resources and more information about the issue, including our No Child Should Be Stateless report, which analyses the safeguards and nationality laws of all the countries in the Council of Europe, and yeah, assess how their safeguards play out. And we also have a policy briefing specifically on the right to a nationality for children in migration, and looking at what the risks are for children in migration in Europe for statelessness, and why there's still that risk for those children, and what needs to happen to prevent that. And then also a useful tool, hopefully, is our Statelessness Index, which is an online comparative tool which currently has information on 27 countries across Europe, including the UK. And the Liverpool Law Clinic is one of our country partners on the UK. And it provides information on statelessness law, policy and practice in the 27 countries, including on childhood statelessness and the prevention of statelessness, but also on a range of other topics like detention, statelessness status and determination. And one of the resources that we've developed out of that is a specific briefing on birth registration in Europe, using the data from the index to assess law, policy and practice on birth registration across the countries that are included. So hopefully that's also a useful resource on childhood statelessness. And yeah, I'll share the links in the chat as well as on the presentation slides. But I'm aware I've probably gone over time, so I'll say thank you and hand back over.
Thank you so much, Khadija. Thank you. I'm going to now introduce our final speaker, Eric Fripp. Just bring you onto the screen, Eric. Thank you for joining us. Eric is a barrister at the 36 Group in London, specialising in refugee law, immigration, nationality and human rights law. Eric has appeared in numerous leading cases and undertakes advocacy at all levels of domestic and international court or tribunal, as well as advisory work. He's recognised internationally as an expert on nationality and statelessness and their interaction with international human rights instruments. Eric's publications include Nationality and Statelessness in the International Law of Refugee Status and the Law and Practice of Expulsion and Exclusion from the United Kingdom. Thank you, Eric. I know that you're going to talk to us about the case of Shamima Begum and the responsibility of legislators in that context. I will get up some
Thank you,
slides
Rebecca.
for you.
And I'll come to some broader issues at the end of it. Can I ask, I think we're about 15 minutes late. Do I still have 15 minutes or do I have
Absolutely.
a minute?
You have
Okay.
15 minutes, not a minute, and we'll have a slightly reduced time for questions at the end.
Good. Well, thank you very much. And thank you to HRLA for inviting me. Thank you very much to my fellow panelists, because in the course of some discussions by telephone and email, I've been very stimulated by exchanges about some of the issues around this. What I'm going to give you, I'm afraid, to a substantial extent, it's a view from the air. So I've got to cover quite a lot, pretty quickly, in particular to get to statelessness, because ultimately the Begum case wasn't about statelessness for reasons that I will explain. You should have two background items. One, we'll go soon to my slides, and I'll take you through using some slides. Two, you have a handout that I prepared, or rather collated. None of that is editorialized, it's just the basics relating to the relevant law. And that, I think, has been advertised in the chat box on various occasions. I'll refer to some of the instruments there to, I think, familiarize you with them. They're set out very plainly. So let's go to the slides. And the Shamima Begum case, of course, is laterally, and it may yet reappear in Strasbourg, but for the moment, the last iteration of Shamima Begum has been in the UK Supreme Court. I'm going to give you the background facts, which are pretty familiar, very shortly at slide number 2. So she left the UK in 2015. She was a schoolgirl. She left the UK in 2015. She was aged 15. She traveled to Syria. She aligned herself with a terrorist group there. And disappeared until she appeared in a displaced persons camp, still in Syria, some years later in early 2019. The Secretary of State took a decision to deprive her of her nationality under Section 40(2) of the British Nationality Act. That you have in the earlier handout, the source materials, at paragraph 15, and the key passages are highlighted on page 9. So first, the Secretary of State may by order deprive a person of its citizenship status, here being a citizen, if satisfied that deprivation is conducive to the public good, but subsection 4, Secretary of State may not do so, if satisfied that the order would make a person stateless. The response to that, ultimately, was that she entered notice of appeal against it. She also sought entry clearance on the basis that it was her case, ultimately supported by the Special Immigration Appeals Commission, that she couldn't take part in proceedings so as to enable there to be a fair trial of the issues arising, whilst she remained in the displaced persons camp in Syria or elsewhere in Syria. And when that was refused, she appealed that. In addition, she applied for judicial review, because the ambit of her appeal against the entry clearance refusal was limited to human rights, she judicially reviewed it also in case there was any material to cover outside the ambit of human rights, the belt and braces approach. Moving to slide 4, the initial conclusions by SIAC, so that was appealed. It went to the Special Immigration Appeals Commission. First, at the date of deprivation, she remained a dual Bangladesh national, so she wouldn't be made stateless. The barrier that the Secretary of State couldn't make her stateless on that date, I'm so sorry, the barrier that the Secretary of State couldn't take away her nationality on that date if it would make her stateless, wasn't engaged. Something that you may find interesting about the SIAC finding is that it considered the law of Bangladesh to be as follows. You know, Ms. Begum had been born a dual citizen. That is, she was a Bangladeshi citizen from birth under the law of Bangladesh. She hadn't been deprived of that automatically by being a British citizen, but she would when she turned 21, which would happen in August of 2019. Of course, she was deprived of British nationality in February 2019, and so she didn't reach the point in August 2019 when she would have lost Bangladesh nationality. Had the Secretary of State taken no action and considered the position again in September 2019, arguably on the construction of law, the Secretary of State would have been prevented from applying Section 40 brackets to deprive her of nationality. The holding of SIAC was that she couldn't have a fair and effective appeal in Syria, than that the Secretary of State had been entitled on review, judicial review type principles, to decide that the deprivation decision didn't expose her to real risk of breaches of Articles 2 or 3 ECHR, which were considered under a policy of the Secretary of State on the assumption of or rather the policy fiction of extraterritorial effect. Next, she appealed to the Court of Appeal, and the Court of Appeal, this is slide 5, held that fairness required her to be admitted to the UK to participate in her appeal, and that SIAC had erred in applying a review approach rather than a much more intrusive merits approach of deciding itself the question to the risk issue, and that the issue of whether her coming into the country was a material national security risk could be considered by the court. It didn't have to be left in a deferential way to the judgment of the Secretary of State. The Secretary of State appealed all of that to the Supreme Court, effectively. And so the issues for the Supreme Court, slide 6, did she have to be granted entry clearance where she couldn't otherwise have a fair and effective appeal? If she was unable to enter the UK or participate in effective hearings, must the appeal be allowed? Was SIAC wrong to apply the review type approach, or was the Court of Appeal wrong to hold it should have applied merits appeal? The answer to those, respectively, is to small Roman 1, no. Small Roman 2, no. Small Roman 3, SIAC had been correct and the Court of Appeal was wrong. So the Supreme Court allowed the Secretary of State's appeal, and you have it at slide 7. That's given it to you quite quickly, well, I hope, because that's really the beginning of the description of what it reveals. I mean, what it reveals in my view is the coming together of two elements that have been produced by the enactment and amendment of statutes over time, in particular, in the wake of 9/11 in 2001, which have had the effect of creating an extremely broad deprivation power a relatively unconstrained deprivation power, and a very ineffective appeal remedy. There's a film called Contagion. So we're in a pandemic, and Contagion's about a pandemic. And at one point, an expert at the Centers for Disease Control says to another one, as they're looking through the microscope at the virus, well, you know, somewhere in Asia, the wrong pig met the wrong bat. And the pig and the bat in this telling are the deprivation power and the appeal right. I'm going to try to deal with this pretty quickly to move through to deal with some broader matters about deprivation and statelessness. But in effect, you know, coming to slide 9, I want to show you how we get to where we are by the changing iteration over the seasons in relation to this. So slide 9, it gives you the deprivation power until 2003, so covering the 9/11 period. Deprivation by order, if a citizen has shown by act or speech to be disloyal or disaffected towards Her Majesty, or during a war has unlawfully traded or communicated, within the period of 5 years, well, I'm sorry, C is irrelevant for our purposes, but you had relatively exigent, and also, it has to be said, relatively old-fashioned language and restrictions on the right or the power of the Secretary of State to remove an individual's nationality by order. Then there was amendment by the Nationality, Immigration, Asylum Act 2002. So slide 10. This simplifies the test to whether the person has done anything seriously prejudicial to the vital interests of the UK or a British overseas territory. But what's happening during this time, I don't have the time to take you through the whole ladder, is that there are cases coming up and the government is getting frustrated that cases fall outside these standards. And so the government is legislating to try to move ahead of the next case. And so they do that by the 2002 Act. You get what you see at slide 10, but they decide to do it again, slide 11. And so that's what we've got now. Secretary of State may by order deprive a person of citizenship status if satisfied the deprivation is conducive to the public good. It's extraordinarily open. Some of you will know that that is part of the test for deprivation under the Immigration, I'm so sorry, for deportation under the Immigration Act 1971, Section 3.5 of that Act. The Secretary of State believing it is conducive to the public good is the first stage. And that only opens the way to a second stage where the Secretary of State has to decide whether to exercise the power. I mean, here you have one layer and you have this very broad test. I'll come to show you how broad the policy around it is also. So, the interpretation of that language is the interpretation of that language prone to narrow the scope of it. Answer no, slide 12. So if the Secretary of State is satisfied, there are abundant authorities in domestic administrative law that say, well, the Secretary of State can't be unreasonably satisfied, but that leaves open the question of what standard of review is attracted there, whether it's Wednesbury type review. And in Begum, Lord Reed at para 66, the discretion is one that Parliament has confided to the Secretary of State, to the executive, and the condition isn't that SIAC is satisfied. So it's not SIAC's view that matters. SIAC is essentially limited to reviewing the Secretary of State's view. Next, slide 13. The language of conducive to the public good. It's a broad test, and I've referred you to the deportation provision, and there's all authority on that. And then the policy, you'd think, is there a very detailed policy? You know, ideally a sort of statutory instrument, or some sort of embedded policy that restricts the use of this broad power. There isn't. I mean, the Secretary of State publishes guidance. The guidance could be changed overnight. You could wake up tomorrow and find that the guidance has been changed. You could come out of this seminar at the end of it and find that the guidance has been changed. What the guidance says, conduciveness to the public good, means is that it means depriving the public interest on grounds of involvement in terrorism, espionage, serious organized crime, war crimes, or unacceptable behavior. Unacceptable behavior seems the weakest of those. Perhaps you interpret that as having to have equivalent seriousness to the others. You still have a very broad range, and you have to remember that the Secretary of State could change that almost moment by moment to weaken it, or specify a less compelling activity. Next, so our slide 14, appeals. This is more complex, and you have the slides, or you'll have the slides, I hope. I'm going to go through this pretty quickly, but in essence, you started out in 1997 with the Special Immigration Appeals Commission Act. The Special Immigration Appeals Commission essentially deals with immigration appeals where those involve, where there is a certification by the Secretary of State that those rest on security material that shouldn't be dealt with in the ordinary tribunal system, and they're shunted off to SIAC. In practice, most of these deprivation cases, almost all of them, are dealt with in SIAC. So it's established in 1997 because the previous extra statutory procedure is found judicially to be insufficient because unaccountable and over secret. So we move on then from the establishment under the SIAC Act to Section 4, which was part of the initial regime from August 1998, slide 15.
Eric, just a quick reminder about timing, because I think
Sure.
we're approaching the Q&A.
Okay, so
Thank you so much.
Certainly. So you see, you had until 2003 what looked like some direction to the subject matter of the appeal, but that was rescinded by the 2002 Act. Since then, there's been a lack of other material to direct SIAC as to what its scope is. And so Begum says, essentially, given the rescinding of Section 4 in 2003, in fact, SIAC in general has an extremely restricted span of appeal. I mean, so I've concluded that at slide 26. In essence, the legislature, at the behest of the executive, has produced an extremely broad power with a very circumscribed appeal. And it's come by successive parliamentary action in widening the scope for deprivation after 9/11 in particular, and in removing prescriptive statute that lent substance to the appeal right in the same period. Next, some general conclusions coming away from the specific example. So Begum in the Court of Appeal, there was no issue about whether she was stateless. SIAC had rejected that. That wasn't appealed. It wasn't part of the Supreme Court proceedings either. But what Begum does is to confirm the existence of mutually reinforcing weaknesses. And at slide 28, some things to reflect on post-Begum. One is the sheer breadth of the power, the restriction of appeal, their mutually reinforcing weaknesses. Two, a case called Remen, which you have back in the notes. You still have to consider the serious consequences of deportation for the deportee. But in practice, the facts of many of these cases, like Ms. Begum's case, involve deportees who, or translated to deprivation, people who've been deprived of nationality, whose actions make them extremely unattractive as subjects for that sort of argument. And one of the weaknesses overall of the whole system is a lack of legal weight, or the lack of any constitutional grounding or any legal weight given to the civic value of retention, of solidity, of citizenship, as opposed to precarity of citizenship. Let's move on to the next slide. We're getting close to conclusion. So will ECHR rights develop? ECHR is the weakest instrument as regards nationality rights. There's no express nationality right at all in it, contrasting with, you have it in the handout at paragraph 14, the American Convention of Human Rights and the Inter-American System that has much stronger provisions. That reportedly, that is the weakness of ECHR, reportedly came about because in 1950, the drafters and the states were extremely concerned, given the recent deportation under the Potsdam procedures of many ethnic Germans from, and in some cases ethnic Hungarians from Eastern and Central European states who were expelled, in the case of the Germans, mostly to the territory of the German Democratic Republic, or what became the Federal Republic. And there was an unwillingness to create a regime with a protection of nationality mirroring what had been in the Universal Declaration in 1948, because that would have threatened the unraveling of the denationalization and transfer of populations, which the Allies had conceded, in which they'd actively cooperated during and after the Potsdam Protocol. So ECHR is extremely weak, albeit there is a line of jurisprudence developed under Article 8, and Genovese v. Malta and Hoti v. Croatia, which was referred to by Judith. Is there potential for that to develop? Next, it's worth noting that there are broader international human rights laws, which are usable as lex specialis when you interpret less specific ECHR provisions, such as Article 12.4 ICCPR. Moving on to the next slide. And also, it's important to reflect on the narrowness of the statelessness constraint. So the restraint is only engaged when there would be de jure statelessness. Even an individual who's not made stateless by deprivation can in fact be in a very negative position, and a position that's negative for the individual and for the international community. An example is Ms. Begum. So she's not de jure stateless, but she's effectively stateless in the particular sense that there's no state that accepts responsibility for her. She has nowhere to go. That's bad for her, but it's bad for the international community, you might think, to create a body of people who may or may not be acquainted with terrorism or subject to influence by terrorists or terrorist encouragers, who have few other options because of effective statelessness. So so long as she's not rendered de jure stateless, section 40(4) is still disapplied if the state of nationality is a potential refugee convention persecutor or an UNCAT torturer. And again, that's potentially relevant on the evidence in the Begum case as regards Bangladesh. Next, 40(4), it only matters at the date of decision. What happens the minute after doesn't matter. So it encourages states to race for the trigger, to try to beat each other to it, where that is possible. And it gives results that ultimately are in humanitarian and human rights terms potentially highly offensive. Finally, determining foreign nationality laws is not straightforward, as these cases have gone to show. Judith and I think, have joked over the years about how courts used to assume that all you did to prove nationality or the lack of it was go to the responsible embassy and ask them for the written note that they would give you, providing a true account of your nationality or lack of it. And so the SIAC cases have been a curative influence on the judiciary in that sense. And finally, final matters to reflect on. Perhaps the most important one is the problem of weight. Courts recognize that citizenship is very important, but what does that mean in practice? Does that mean it's important not to remove it from people, or does that mean it's important precisely in the opposite direction, that it's important to remove it from people who aren't worthy of it in relevantly acute ways? What is the public value of individuals who otherwise are unattractive retaining nationality or in the restraint on extremely broad executive powers? And how do you give this weight in law, given our constitution? You have comments like those of the late Sir John Laws, Lord Justice Laws in G1, Lord Conwath in FAM, and latterly David Richards in Lord Justice David Richards in the PR CBC case. But what do you get from that? I mean, the appearance from the current jurisprudence is that in the face of statute, you get very little apart from emetic or rhetorical support. So finally, we come to a conclusion, which is just to say, well, next slide, 32. Thank you very much. I do, just in closing, go back to something that Amal said. Amal views statelessness and nationality in a human rights way. That's reflective of a development over time. I mean, the international law relating to nationality begins essentially as a matter of the traditional international law operating state to state and of humanitarian purposes within it. In the 1930s, the leading scholars, most of them believed that it would be possible to move towards codification of international law to reduce, certainly starting from the reduction of conflict and then going on to increased codification towards common standards. That never happened. And indeed, what we could call the state-to-state law relating to nationality has really changed very little since the 1930s. But what has changed is the growth since the Second World War of human rights law that has imbued that even in this a relatively protected area of state activity has provided a number of very important standards and continues to develop. So you could see it as a mixed system in transition, or which has been in transition to a human rights orientation from another one. Thank you very much.
Thank you, Eric. I'm afraid I think we've run over a little bit for time, but if the speakers are happy to stay on for a couple more minutes, I think we've had some interesting questions from audience members. Are people happy to stay for a couple more minutes?
Yeah.
Thank you. So I'll just bring everyone up. You're welcome to bring yourselves off mute if you want to. Thank you all for really, really fascinating presentations and discussion. I know that Joe Bezzano is also joining us for the Q&A and has answered a few questions already in the Q&A function. Christiana, I might direct this one to you. Someone has asked, what can we all do to support the work of State Free and what would be most useful? Do you have any thoughts on that?
Yes, so I guess in general, to support the topic of statelessness, I would say something that helps is simply creating awareness. So now that you've learned about the topic, also sharing it with your surrounding, with people who you know, and you might know that they don't know about the topic of statelessness, because one of the main issues is also that it's very invisible. So how would we solve a problem that nobody knows about? And in terms of State Free, just spread the word. So we're happy about everyone who decides to join us and everyone who is willing to be part of this journey. And just share the website also, and encourage people to register on and put their name on our list.
Thank you. I can see, Khadija, you've also been answering some questions in there. We also have a question. Well, before moving on, I mean, do any of the other speakers want to follow on from what Christiana said about what people can do, what they can take away from this event? It's obviously a lot of information. A lot of it might be quite new, and a lot of different aspects to the topic. Is there anything that you'd say lawyers working in human rights or students or people interested could do as next steps?
I mean, if I can jump in on this, Rebecca, I would say that if you're interested in the issue, take it upon yourself to educate yourself on the issue, to learn more, and particularly to speak to people who have direct lived experience of statelessness, or to read their writings. There's a lot of material out there, fantastic articles, webinars, podcasts, and just I would say try and grapple with this issue for the deeply human issue that it is, because it's through understanding the way in which statelessness as a condition which is imposed on people by other people, the way it impacts on individuals and families and communities, and ultimately the way it also impacts on our societies. That I think that's where I draw my inspiration to work on this issue, and I think that's where you would see why it's such an important issue to be combating on a day-to-day basis. No one should be stateless. There's no good reason for people to be stateless. And if people are stateless, it's often due to oversight or a lack of awareness, but it's mostly due to deliberate policy, which stems from the idea that some people have less value, some people have less reason to belong, some people are more dispensable, and that's quite a reprehensible basis for any policy decision. whether it's targeting individuals, whether it's targeting communities. And so I would urge you to educate yourself, and you will, through your own process, find out where you're best suited to continue to engage on the issue.
Thank you so much, Amal. Did anyone want to add anything else? I'm kind of keeping it open to everyone to chip in if you'd like to.
Well, I'd endorse everything Amal has said. I see Donald's question. Has that been answered? I mean, if I can address Donald's question briefly. I mean, Donald, there is a case about this, in fact, and I think Amal will be smiling and Judith will be smiling. And
Eric, sorry to interrupt, but the people, only we can see the questions, so you need to say what the question is.
I'm so sorry. I'm not very good with the tech. Donald Broach has asked, redeprivation of UK nationality. Is there a legitimate distinction between the nationality of another state and mere entitlement to it? It's a very good question, because section 40(4), that is the prohibition on deprivation of nationality on a conducive basis, if that would make someone stateless. There has to be a de jure nationality at the time. An entitlement doesn't do. I mean, there was a case called Al Jeddah. In Al Jeddah, what the Secretary of State found frustrating was the Secretary of State said, well, if Mr. Al Jeddah tried harder to get his Iraqi, I think, nationality back, then he might have got it. So what we should define section 40(4) as including people who are de jure stateless, unless they're de jure stateless because they're lazy about helping us out. And that was rejected really that was kicked out of court, that one. But there are many circumstances where the possible entitlement is relevant and is aggressively raised by states. And one is possible alternative states of nationality or of former habitual residence, which goes to the Refugee Convention. To be a refugee, you have to have a well-founded fear of persecution in each of your states of nationality, or if you're stateless, in every state of former habitual residence, or every state treated as a state of former habitual residence. And so the Secretary of State will argue, and the Canadian authorities argue very aggressively, that the ability to apply for a nationality should be treated as though it was a nationality within the interpretation of the Refugee Convention. So that's an example. There are other examples. The new ineligibility provisions in the UK immigration rules, whereby the Secretary of State is going to try to stop people getting into the asylum system by saying you should go elsewhere, is likely to raise this as well, and in giving a very broad range of places which are considered to be alternative destinations. Yep, thank you.
So thank you to everyone who has asked a question in the chat function, and thank you to the speakers for their written answers. I'm conscious that we've run over time quite a lot, so thank you for staying with us and for all your contributions. Judith, was there another question that you wanted to answer, or did you want to? Had you already written it? Okay, thank you. Well, thank you so much to all of our speakers for joining us. It's such a rich subject, and I'm sure that we could go on all evening, but we need to let you go. Thank you for all of your contributions and for the sort of exchange of ideas. I'd like to thank again One Pump Court for also hosting us on their Zoom this evening and for their technical support. And just encourage everyone to join the HRLA, investigate the human rights internship bursary that we have. if you're interested in that, and also to follow, the work of our panelists, to follow the work of ISI and ENS, have a look at some of those reports, sign up to Christiana's online platform, and yeah, hopefully you'll take a lot away from this evening. Thank you all for joining us.
Thank you.
Thank you.
Thank you very much.
Take care.